I'm doing a check right now to see who we've got. Yeah, we're still missing a few.
Well, it's not even 10 o'clock. Let's give them a couple of minutes.
Tweety.
Mr. Young. I see you've joined us. Judge Savaggio, are you looking at Representative Leland's screen?
I was, and I was going to comment on it, and then I thought, well, I don't really know him very well, so
It is a baseball name, you know.
Making skills, and I refrained.
Well, you do know Leland is a baseball name.
I've, as an Indians fan, yes, painfully so.
Unfortunately, as someone from Cleveland, I'm not used to seeing baseball in October.
We all saw it in 2016.
True enough. True enough.
David, are you related to the?
I'm not. I always make jokes about that when he was in baseball prominence. I'd say, yeah, Uncle Jim, is doing this and Uncle Jim is doing that,
Yeah.
But no, we're not related.
So in the small world, just to share a real quick story and then we'll get started. My son is actually a scout for the Detroit Tigers.
Oh, wow.
In Major League Baseball. And his territory is the Mid-Atlantic. And he gets a call on Father's Day, 10 o'clock in the morning. And my son's name is Matthew. Mark. And so my son hangs up, call comes back. It turns out to be Jim Leland. Jim Leland calls my son, hey, I got a kid. I'm on a golf course in Pennsylvania. I'm talking to a guy. He's got a son. I want you to go check him out. So that was my son's first and only interaction with Jim Leland.
So I'm on the board of directors of the Columbus Clippers here in Columbus.
Oh, yeah.
We have a few games with the Mud Hens every year.
Yeah, just a few.
That are very, very exciting. Very exciting.
Yeah, absolutely. It's a great rivalry. So, okay. Let's see. 10:02. How are we doing, Justin?
Yeah, we're just missing Meredith O'Brien. Oh, here she is. And then Attorney General Yost isn't here, but I see Doug DeMoult, his non-voting designee, is here. And then Senator Gavrone, who I mentioned would be late. So it looks like we've got everybody that's
excellent. So let's get started. Thank you all for your promptness in attending today's meeting. We'll call the October 22nd meeting of the Task Force on Conviction, Integrity, and Post-Conviction Review to order. The first order of business, as you'll see on your agenda, which each of you should have received, is the approval of the September 17 meeting minutes. Hopefully you've all had a chance to review those minutes. Are there any motions to amend, modify those minutes? If not, I would look for a motion to approve.
So move.
Let's see, I don't know who moved.
Judge Cost.
Judge Cost moved for approval. Do I have a second?
Second.
By Representative Leland.
Correct.
Okay, thank you. Any discussion? All in favor signify by saying aye.
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 Opposed, same sign. No opposition. It's passed unanimously. Thank you. Number 2, survey questions for prosecutors. So we provided each of you the survey questions per your requests. Those were questions that we had promulgated that we were attempting to send to the prosecutors before our initial meeting, and ask for your input. We have not received any input from any of you, which I take to mean that none of you found any offense to the questions that were posed. What I think we need to do going forward, however, is let's wait until, in particular after today's session, and we hear our guest speaker, Professor Holloway, We may want to modify some of the questions, and then we'll have a more vibrant discussion as to whether or not we want to, as a task force, send out the questions to the prosecutors in light of the position they have presently staked out relative to their lack of engagement with respect to this task force. Just wanted everyone to know that that's there. We'll come back to that in a little bit. Item number 3, a little more housekeeping, which is correspondence requesting investigation of specific cases. I don't know if any of you, because this is a open, public, transparent process that we're conducting. The task force, everything that we're doing is being recorded and is being logged on the Supreme Court website. Individuals can, the public can look and see who other task force members are. Some of you may have, or in the future, you may be receiving specific correspondence pertaining to a case and seeking your input or guidance or direction or assistance relative to wrongful conviction. I don't know if that's happened to any of you as yet. It might, which is why I asked that it be placed on the agenda. We are attempting to collect and collectively respond as these requests come in. And if you have received any, I would ask you to forward them on to Justin, who will be collecting them, and will attend to it in that regard. Your participation in the task force in no way obligates nor imposes any obligation that you should be involved in responding to any specific case for which correspondence might have been received by you. And I don't want any of you to feel that way, but I also we want to, as a task force, be aware of whatever input and correspondence the task force itself is receiving, either collectively or individually, based on your respective positions. So I would ask your cooperation, and if any of you have received correspondence or in the future receive correspondence, to forward that to Justin for our consideration and handling. Okay. Just out of curiosity, has anyone participated in that? No one has received any? Okay, great. Let's see. So we also gave you a wealth of material, and I hope you all have had time to review that. You should have received two sets of items. First, there's a 50-state survey on post-conviction review, which attempts to collate the various practices of post-conviction review that exists in the other states outside of Ohio. And then there's I think an excellent review of the post-conviction practice that currently exists, the status of the law in Ohio, both as it relates to statutes as well as case law. Each of them have been submitted to you per your request based on the discussions at our last task force meeting, and I think help provide a framework for what we do here in Ohio, to the extent that some of you were not aware of that or the nuances that exist there. And more importantly, how other states have attempted to address post-conviction issues in general, and conviction integrity or innocent allegations, wrongful conviction allegations in particular. We do have a presentation with Professor John Holloway next. What I would like to do is I just want to recognize that you've received that. We'll discuss what we're going to do with that information after we hear from Professor Holloway. He's been gracious enough to agree to participate and provide us with his thoughts. I would like to, unless there's any objection, I would like to proceed to that immediately, devote the bulk of this task force meeting today to his presentation. As we proceed with introducing and then having his his presentation, I would let you know that in discussions with John, we would like to have, if there are questions, rather than holding them until the end of his presentation, we don't mind, and I think we're going to be equipped, Justin and Michael, right, to be able to deal with those questions as he presents. in order to facilitate that, there's two ways of doing it. We do have the chat function on our Zoom call. So if you want to, you can write out the question itself in the chat box. You'll see at the bottom of the Zoom screen. If you go down there, the word chat, that's where you, I don't know if any of you have had the opportunity to, but that's where you can put questions if you want to write the question, and we'll vet them with Professor Holloway as he presents. The other way we can do it is to raise the old-fashioned school, raise your hand so we can, and Professor Holloway can then, because he is a law professor after all, John can, right, you can say hello and perhaps address the question in that regard. So
just on that though, because he's going to be sharing his screen with his PowerPoint slides, we wouldn't really be able to see people raising hands. So I would recommend that they use the chat, even if they want to say, hey, I have a question in chat, and then.
Okay, I forgot about that. That's right, because he does have a excellent PowerPoint that he's going to be presenting or utilizing in this presentation, I should say. All right, so now we have the proper protocol. Thank you, Justin, for that clarification. Any questions, anyone, before we get started? Oh, and I see Andy Wilson has joined us. Thank you. Andy, good to see you.
Gene, I have one question. Did you receive a response to the letter you sent out to prosecutors?
I received, actually, I did not receive something. Justin received an email response from Lou Tobin, and we'll send you a copy of that. He believes the calling of John Holloway, it was not in opposition to the letter we sent out, but he thinks that Professor Holloway's presentation and his report of 2016 that he's going to refer to, that's in our reference materials, gives credence to the position that they've staked out, I think is the best. Would you agree that's what it says, Justin?
Yes, that's correct.
So it was a curt, simple, so thank you, but we think this only establishes why we shouldn't be at the table, so to speak. So it'll be, and it puts Professor Holloway in an interesting little box, so which I'm sure he can extricate himself from.
Excuse me, Your Honor.
And Rocky will send a copy of that email so that you have that and you can see that itself. All right. I think we got it Monday or we just got it. So.
Thank you.
You're welcome. Any other questions before we get started? All right. Then let's turn to our guest speaker, and I'm excited to introduce John Holloway, who is an associate dean and executive director of the Quattrone Center. Is that how you pronounce it?
That's it. Perfect.
Yes, for the Fair Administration of Justice at University of Pennsylvania Law School. I'm excited about his willingness to participate in our statewide task force relative to conviction integrity, wrongful conviction, and post-conviction review process. We did provide to each of you his biography that's attached as one of the matters that you would have received, and you can see he's written extensively relative to conviction review units and the like, and currently serves, as I said, as the dean of that program, as well as a law school professor. Professor Holloway, I want to thank you for your willingness to join us today and give us your thoughts and directions. And at this point, I'll turn the floor over to you for your presentation. Professor Holloway.
Thank you, Judge. It's a pleasure to be here, and I want to just sort of acknowledge how I think valuable this task force is and is going to be, how important these issues are, and I want to offer my compliments to everybody here for participating in it. I didn't realize that I was at the center of a political maelstrom, but will certainly do my best to be to talk about sort of the work that we do and how I think it might relate to things that you all are talking about. So I'm just going to take a moment and share my screen. Can you all see that? Hang on one second. I don't know why Zoom does this, but when you share your screen, it then closes the video panel. So I can't then see your faces until I reopen it, but now I can. And so, Justin, I appreciate your help with the chat room. I think I can see most of you. And so if that, and I also respond well to just simply being interrupted. So feel free to just unmute and interject at any point as we go through. So as Judge Zamuda said, I work at Penn Law, and I, since 2013, have worked with the Quattrone Center for the Fair Administration of Justice. I helped to found the center. It's been around since 2013. And what we do is we work with jurisdictions around the country to look at criminal justice really as a system. So we don't represent clients. We don't take on cases. We do data-driven research projects. And we try to take that data and then sit down with people throughout the criminal justice system in a region and use that data to help them improve the system and make sure that we're satisfying the purpose of the criminal justice system. And I would argue that the purpose of the criminal justice system is to identify and hold accountable perpetrators of crime in ways that preserve our constitutional rights, and then to hold those people accountable for their actions in ways that help over time to reduce crime in a jurisdiction. So I would say, get the right guy in the right way and do something useful to reduce crime. And so while we do look a lot at wrongful convictions, I think we actually look at what we would call errors in the criminal justice system. And errors from a systems perspective is any outcome that the system is not designed or not intended to generate. So a wrongful conviction is an error in the system because we don't want the system to get the wrong person, right? Whatever you might think about what should be a crime, whatever you might think about how we should sentence somebody, I think everybody can agree that we only want to hold somebody accountable if they actually committed the offense for which they've been charged. So you get the wrong guy, that's an error. But a cold case from a systems perspective is an equal error. It's kind of the flip side of that error. We got the wrong guy, cold case, we didn't get the right guy. Right? So both of those things are errors. And I think it's important to start with that perspective because when we're talking about wrongful convictions, at least from a Quattrone Center perspective, there's no particular reason why prosecutors, in my mind, should be threatened by what we're talking about. Because what we want to do is help the system do what the system's supposed to do. Get the right guy, don't get the wrong guy. Both of those are errors. I would argue that an officer-involved shooting is an error. And that's true, and this is the asterisk in the bottom right corner. Error and blame, not the same thing. Okay, when the system generates an outcome that we don't want, that's an error. We want to learn from it. We want to try to prevent it. That is not the same as saying that somebody did something they shouldn't have done. There are plenty of officer-involved shootings where officers act within protocol. They do exactly what we're training them to do. They act exactly in accordance with the rules. The simple fact is we don't want situations where officers are forced to do that. It may happen anyway. We may have some that are unavoidable, but we want to learn from them and try to prevent them over time. Same with wrongful convictions. As we'll see when I go through this, I think the reason that there are a lot of wrongful convictions is not because people are deliberately acting badly. I think it's because the system creates environments, things that we don't know about, people doing things in complex systems of dynamic information, imperfect circumstances. And the question is, if these things are happening and nobody wants them to happen, why do they keep happening and how can we prevent them over time? So think when we're talking about wrongful convictions, I just want to emphasize, we're talking about preventing errors in criminal justice, but we're separating the concept of an error in the system with the blame for an individual or a group. So one of the things that the Quattrone Center does is we try to learn from these errors by taking principles of root cause analysis that come from healthcare, transportation, other complex systems which, like criminal justice, involve groups of people acting in dynamic circumstances, generally stressful circumstances with people's lives at stake, zero tolerance for error, lots of information changing hands. And we try to do reviews where we take blame out of the equation, we gather all the people around, sit down, learn from those events. So for example, we have a group that meets monthly in Philadelphia. Membership from the DA's office, our public defender, the Court of Common Pleas, which is our trial court, and the Philadelphia Police Department. They nominate cases. We sit around, we figure out from those cases what the contributing factors were that generated the undesired outcome in the case. And then we work together to think about how each of the organizations could have handled the case differently and work with them then to implement reforms that will prevent the next wrongful conviction, the next officer-involved shooting, the next death in custody. We call these sentinel event reviews, and that's what led us actually to then working on conviction integrity units. I want to talk just briefly about wrongful convictions, and how they happen nationwide. We know that these errors happen much more frequently than anybody wants them to happen. As of 2 days ago, or Monday, when I sent these slides out, we were aware of 2,678 exonerations across the United States. These are cases where there was a conviction or multiple charges. All of the charges were overturned, reversed, dropped, and no plea bargain, no criminal charge was then actually done. So it's a pretty conservative view. 2,678 nationwide, almost 25,000 years of incarceration for crimes that people haven't committed. Ohio is unfortunately not immune from this challenge. There are 84 known exonerations, totaling almost 1,000 years of incarceration. And the slide on the right, the database that I'm drawing from is the National Registry of Exonerations. Got started at the University of Michigan, now housed at the University of California, Irvine. In that database, it's basically 85% of the 2678 are cases that were decided at trial. So not cases that were pled out, but cases that actually went to trial. So 15% of those cases were plea bargain cases. Important for a couple of reasons. One is there are lots of instances where people plead guilty to something that later on we have proven that they don't do. But number two, you can understand why it's more likely in a database of exonerations that you'd have more cases that go to trial. It's much easier to appeal a case when you've gone to trial and you have not pled guilty. But we also know that our criminal justice system doesn't work that way, that in fact, in most jurisdictions, 95 to 98% of all cases get handled by plea bargain. And so we can assume that this 2678 with an 85-15 trial to plea bargain ratio is actually much, much larger in terms of people who have pled guilty to things for a variety of reasons that they didn't do. And in particular, one wonders how often somebody who is being charged with a misdemeanor or a very low-level felony is going to plead guilty for administrative convenience and because of a lack of faith that the system's actually going to get the right result, and simply decide that the easier path is to simply take the charge, get whatever the lower-level penalty is, and then go back around about their daily business. The collateral consequences of that may be huge, but the system's not getting it right, and we want to help improve that. So these are big numbers. I think they're concerning numbers, but the actual numbers are likely to be much larger. This is a number that personally I find haunting. This is the result of a study that was done, published in the Proceedings of the National Academy of Science, which is one of the more prestigious scientific journals in the country and in the world. A group of statisticians got together, and there are actually enough individuals who have been exonerated from death rows across the country that they could create a statistically significant sampling of those people who've been exonerated on death row relative to the death row population as a whole, and using multiple different statistical methods. All three of the methods they chose converged around this number that 4% of all people on death row are likely innocent from a statistical perspective. 1 in 25 people on death row in the United States today is innocent. And the problem is that we don't know which one it is. So there are enough people on death row in Ohio that you would assume that 5 of those people are innocent, just from a statistical perspective, assuming that Ohio's error rate is not different than other places in the country. And there's no reason to think that it's either better or worse. And again, if we assume that, as I do, that most of these are not deliberate misconduct, but instead the system simply getting the wrong result for a variety of reasons not linked to misconduct, we can look at this without any sort of criticism of individuals, but it's something that we need to be aware of. We get it wrong on death penalty cases 1 out of 25 times on the matter of guilt or innocence. So obviously this is a challenge that we need to address, we need to get better at, and we need to figure out how to improve going forward. So this is the question that we ask ourselves at the Quattrone Center. I think every time you talk to a prosecutor, a police officer, a defense attorney, a judge, whoever you talk to in the criminal justice system, and you say, well, why do wrongful convictions happen? And people will say, well, I don't want to be part of a system. I don't want to be part of a case where we get the wrong guy. I don't want to investigate the wrong guy. I don't want to arrest the wrong guy. I certainly don't want to prosecute and convict the wrong guy, right? So if nobody wants them to happen, why do they keep happening? That's the question we ask at the Quattrone Center. In order to do that, we want to learn from them. And in order to learn from them, we looked at what other complex systems do. And so what they do actually is not revolutionary. It's just something we don't do in the criminal justice system. They research them. When a plane crashes, a team of researchers go to the plane site. They put yellow tape all the way around it, and they bring in meteorologists, and they bring in people to read the black box, and they bring in mechanics, and they bring in engineers, they bring in climatologists, they bring in sleep experts, they bring in all sorts of people, and they take a multidisciplinary look. They interview all the people who were involved in the incident, and they come up with a response. And so this is actually a picture from the International Standards Organization, and it's their standard graphic for a quality management system. So when we do this with a plane crash, we're using a quality management system. We're going in, we're examining something, and we're saying, did this plane operate the way our requirements were, right? So we have customer requirements. Did the plane do it? Did our plane go up and plane come down? Or did the plane crash, in which case the customers are not satisfied? I can tell you that right now, right? So the feedback loop is, let's learn from this, let's take that information back, and let's design a better plane and a safer plane. When hospitals have what they call never events, right? You leave a sponge in somebody's body, or a patient gets an infection that they didn't have when they walked into the hospital, or something like that. You operate on the wrong limb, right? You're supposed to operate on the patient's left wrist, and instead you operate on the right wrist. Those events are called never events. Hospitals have peer reviews. They call them morbidity and mortality reviews. They bring together all the people in the ward. They talk about the procedure. They talk about where it went wrong. Based on the various things that contribute to it going wrong, they then implement new policies. That's why error rates have gone down in hospitals. That's why planes are, fly safer and safer, despite the fact that we've got more and more planes in the air. We see fewer and fewer accidents. And criminal justice doesn't do this. In criminal justice, we litigate a case, we have an appeal, maybe we have some civil litigation, and we try to remediate the past error, but we don't have a system that helps us learn from that past error and then take some forward-looking accountability to act differently the next time. Instead, we feel like we've handled it with litigation, right? Justice has been done, and then we move forward. But we haven't learned from the event, and therefore we haven't changed anything that's going to redefine the customer requirements or improve the customer satisfaction for people who participate in the criminal justice system. And it's never just one thing, right? So I'll give you an example in the healthcare context. I broke my wrist, I don't know, 7 or 8 years ago. And I go to the hospital and I'm gonna have surgery. So I've got my cast on, and the doctor writes his initials on the cast, right? Anybody know why that happens? I'm a law professor, I'm good with uncomfortable silence. All right, the reason he wrote on the cast was so that when we get in there to the operating room, nobody operates on my wrong arm, right? They want to make sure that the initials right here on the cast that's what the nurse is trained to look for, that's what the doctor's trained to look for, everybody's trained to look for that, because I'm going to be unconscious and they can't ask me which arm they're supposed to be operating on. So I said to the guy, and by the way, this is done because they've operated on the wrong arm someplace else, and they've learned about this and they've changed their procedures. So I said to the guy, what are you doing? And he's like, what are you talking about? I said, what are you doing? You know what I do for a living. You know I do quality management for a living. What are you doing? And he's like, I'm putting my initials on your cast. And I'm like, okay, and then what's going to happen? He's like, well, I'm going to knock you out. I'm going to wheel you in. I'm going to take the cast off. And I was like, stop right there. You're going to take the cast off. And then where are my initials going to be? And he swore at me and he called me a nasty name. But I wasn't wrong, okay? And this is how quality improves. Quality improves stepwise by making a mistake, fixing it, then making the next mistake and fixing that. It's a game of whack-a-mole. But in order for that mistake to happen, what really has to happen is you have to not know which arm we're operating on. Then you have to try and solve it. Then there'd have to be another error in the emergency room. So we've got miscommunication between doctor and patient. We've got miscommunication between doctor and nurse. We've got miscommunication between nurse and nurse. All of those things come together. That's the idea of this chart here, which is called the Swiss cheese model of error. This comes from a British organizational psychologist named James Reason. And the point is, think about the criminal justice system as this block of Swiss cheese, okay? Think about each interaction, starting with the commission of a crime, going all the way to a sentencing. That's your block of Swiss cheese. Each interaction is a slice of Swiss cheese. And each interaction has some potential for somebody making a mistake. Those are the holes in the Swiss cheese. Our criminal justice system is structured to catch those errors. We have police doing investigations. We've got supervisors who are supposed to make sure that we've got done those things the right way, that we've got the right person, that we're following up diligently, that we're ruling out complex conflicts and leads, and that we're getting the right person arrested. Then we've got prosecutors who review that case and decide to charge it and move it forward. Then we've got defense attorneys to bring their critical thinking to bear and to explain whether or not we really think we've got the right guy. Judges then have a tribunal under certain rules. The rules of evidence are designed to make sure that accurate information, complete information is presented to the finder of fact. And we've got appellate procedures. Each of these are checks and balances. And so normally, if we have a hole in one of our slices of Swiss cheese, it will go through this process and run into a slice of Swiss cheese that doesn't have a hole, and we'll catch that error. But sometimes the hole goes all the way through the block of Swiss cheese. We arrest somebody who didn't do what we said they did. The prosecutor believes that the case is righteous and truthful and takes it forward. The defense attorney either doesn't know or can't prove the innocence of the person for whatever reason, and it goes all the way through the system despite all those checks and balances. What I would say is that means a couple of things. One is, again, we're talking about error, not blame. Because whatever you might think about that case, I'm not going to tell you, there's no way that everybody wants to get that wrong, right? There simply is no way that everybody participating in that case is deliberately doing things wrong. So we have an issue where we've got an error, but we've got an error despite everybody's best actions, which is not often the way we as lawyers are sort of trained to think about things. In the criminal justice system, we allocate blame all day, every day. It's our job. So for the Quattrone Center to come and say, hey, actually, when we're looking at this, we're not talking about blame at all, that can be a difficult challenge, I think, for a lot of criminal justice professionals to think about. But it's really important that you look at wrongful convictions that way, because you're not really going to solve the problem if the problem involves trying to get rid of bad apples in the system. There simply aren't enough bad apples in the system to be causing the volume of wrongful convictions that we see. The second thing that's important about this is when we sit down and we look at contributing factors, we're looking at two things. One is, where did we first go off the rails? But two is, why didn't all of our existing systems of checks and balances pick this up, right? Why didn't we know that a DNA test would have solved this problem? Why didn't we test it? Did we bring the DNA test in and misinterpret it? Did we not do the test? Did we not make the right request for scientific information? What are the various areas? And so in a wrongful conviction, it's an unfortunate thing that the police are the sharp end of the spear here. The errors, you can't have a wrongful conviction without an inaccurate arrest. And so the police always get kind of that they always end up being the start of this. But we always are able to generate recommendations for quality improvement throughout the system, which is why we have the police, the prosecutors, the defenders, and the courts all working on these cases, because each of those are checks and balances designed to prevent exactly the error that we've seen. And therefore, a wrongful conviction is actually a fabulous learning opportunity, because every organization that participated has contributed unwittingly to the error and can learn for procedures that we think will improve things going forward. So I want to pause and I guess do two things. I see the question. I don't know the answer to the question, what percentage of people in prison for life without parole? I don't know the answer to that question, although we can look for it. Now I see a question. You've used a number of terms like exoneration, wrongful conviction, and innocence somewhat interchangeably. Does your group attempt to break down the data more granularly so we can have a better idea what percentage of errors are based upon actual innocence versus more procedural issues? So the National Registry of Exonerations uses the definition of, their definition for wrongful convictions is, as I said, any case where all charges for which somebody was convicted are overturned and no additional charges are filed. So the idea is, I recognize that that is not necessarily proof of actual innocence. And so I'm not necessarily saying that that person is actually innocent. But what I would say is, for me, that fits my definition of exonerated. And I think I use the phrase wrongful conviction without any moral opprobrium being attached to the word wrongful, right? So you could call it an inaccurate conviction, and I'm using wrongful in the sense of inaccurate rather than wrongful in the sense of morally wrong in some way. So I would say that all of the 2,600 wrongful convictions in the National Registry of Exonerations are both wrongful convictions and exonerations, which is not to say that they are proof of actual innocence. And I'm not aware of any way to actually get convincing proof of quote unquote actual innocence. I will say that one area where I kind of struggle a little bit because of the system is I'm not a fan of the phrase wrongful acquittals. In my mind, that's an inability of the state to prove its case, because we live in a world where our system is designed, if we make a mistake, to make that a mistake on the side of innocence, innocent until proven guilty. So we've designed the system to say, Blackstone's law, better that 10 guilty men go free than one innocent person be punished for a crime they didn't commit. So other questions on this up to this point?
Yeah, Professor Holloway. Yeah, I asked the question with respect to persons being in prison for life without parole in those jurisdictions that do not have the death penalty. I mean, is there a way to determine whether or not the numbers would be similar to those sitting on death row that actually, you said 4% on death row. I mean, can we make a similar assumption, I guess, with persons in jurisdictions where there's not the death penalty?
So there is no reason, there's no data to suggest that the percentage of errors are different in cases where somebody's been sentenced to life without parole than they are with capital punishment. There is some reason to think that we identify errors in capital cases more rapidly because capital cases have more appeals. And, you know, as an example, I wrote a book about an exoneree from death row in Louisiana. It was a capital case. Had it not been a capital case, he would not have gotten the pro bono counsel necessary to take his appeals or process them to the point where he would get exonerated. Had he been in life without parole, his case would simply not have been appealed because he couldn't get representation for many years. And the only reason he got the representation he got was that it was a capital case. So in a sense, the death penalty saved his life, in a pretty huge irony. But there's nothing to suggest that our error rate is different in life without parole cases than in capital cases, though there is data to suggest that we're more likely to detect that error in capital cases. Does that make sense? Okay.
Yes, thank you.
Okay. Now, in keeping with the Swiss cheese idea, right, there are lots of reasons why wrongful convictions happen. This is a breakdown of the cases that are in Ohio that we know about. And you see DNA, which is obviously a wonderful way to prove that we have an inaccurate conviction because it's objective scientific evidence. And so we don't have to have a lot of the conversations about belief systems. We can simply say, this excludes John Hallway from this particular crime. DNA is a wonderful advancement in creating awareness around and solving many of these cases. Unfortunately, DNA is not available in a lot of the cases that we look at. So DNA has been an issue in about slightly less than 20%. We do have issues around misconduct, both police or prosecutorial misconduct. Now, I will say, I think that the National Registry of Exoneration's definition of misconduct is a little broader than I think I would use, in that they don't sort of get into intentionality. Instead, they get to, if there has been a Brady violation, a situation where exculpatory information was supposed to be turned over, that is called misconduct. Technically, that's true, but that's not the same as saying that it's intentional. So I want to be clear on that. But there are lots of different reasons: mistaken witness IDs, false confessions, misleading confessions. Sometimes we convict people of crimes where no crime happened. Arson is a really interesting situation. If you were convicted of arson in the 1990s, the things that we thought were scientific evidence of arson in the 1990s, we've now done a bunch of experiments, and we no longer think most of those things show that a fire was intentionally set or an accelerant was used or any of those things. And so there are a number of people around the country who were convicted in the 90s or the 80s and 90s of arson, whose convictions have been overturned. Basically, they were convicted because we thought the earth was flat. And later on, we've discovered that the earth is round. So there are a whole host of reasons why somebody might be wrongfully convicted. And I think one of the things that we try and do, and other organizations try to do, is to educate people about those reasons and implement practices that are designed to improve them. Eyewitness identifications, for example, one of the things that we've learned is that it's possible to unintentionally bias an eyewitness if the individual delivering the photo lineup knows who the suspect is. And so we advocate for what we call double-blind photo administration, which is a photo array where neither the person administering the photos nor the person who is making the identification knows whether or not the suspect is in the lineup or which one it is, right? That removes some unconscious or potential for unconscious bias that might happen, and it makes the photo identification more accurate. We advocate for videotaping of custodial interrogations. Why do we do that? Because there have been instances where people have falsely confessed, and we want to go back and we want to review that interrogation to see if there are possible ways that the investigator has unwittingly planted a story in the individual's mind that the individual has then taken as their story because they just want to get out of the room. And the psychology that happens of people in those situations we've studied, we try to educate people about. So understanding what has gone wrong in the cases in our past and the cases we may discover, and taking those learnings and helping them move forward is what we're going to talk about. And in particular, the use of conviction integrity units or conviction review units to do that. Interestingly, Ohio has a couple of conviction integrity units, but they've only been involved, that I'm aware of, in 4 cases of exoneration to date. So where do conviction review units fit in? You don't have to look at this chart in all complexity. I'm just going to tell you, this is a chart from the Bureau of Justice Statistics of the criminal justice system. The message to this is something you already know. The criminal justice system is complex. There's a lot of stuff going on. Everybody's trying to get it right. Where do conviction integrity units fit in? So conviction integrity units are something that we've spent a fair amount of time studying. The report that you see here, which we published in 2016, was a review that we did of a detailed survey of 21 of the first 25 conviction integrity units, because they were starting to pop up around the country, but they were popping up kind of ad hoc. And everybody was dividing their own rules, figuring out their own structures, and everybody was doing it a little bit differently. So we went around the country and talked with everybody about how they were doing it so that we could provide a guide to jurisdictions for practices that were being effectively in place and that were creating units that were actually useful for their communities. One of the things that, so what is a conviction integrity unit? So it's an organization within a prosecutor's office, within a DA's office or a state's attorney's office, that conducts an extrajudicial, so outside of the courts, fact-based review of a case where we've already secured a conviction, but we believe that the petitioner who has been convicted has a plausible claim that they are actually innocent. Now, I am not an expert on Ohio post-conviction review, but in most states, there is no claim for actual innocence in a post-conviction review setting. You're reviewing due process, you might have newly discovered evidence, there are kind of proxies where we try to get at that, but in most states, there is not a claim where you can say, hey guys, I know I'm convicted, but I really didn't do this, and have that be something that actually gets you a judicial hearing. Conviction review units were created because I think viscerally, most of us feel that if you really are innocent, we should do something about that. But the courts, the post-conviction review in most states, don't create always a plausible way to get out that. So the conviction review unit was created to do that. And we started looking at them because one of the things that happens is because this is enclosed in a prosecutor's office, a natural concern, if you were a skeptic, would be to say, well, I can't trust that conviction review unit. The prosecutors, this is the fox guarding the hen house. You're expecting a prosecutor's office to review a conviction that prosecutor's office got and decide that it's wrong, even though a court's not telling them. I don't think that's real. I think this is a smokescreen. I don't believe it. And so one of the things we wanted to do was look at units where they'd managed to build that trust with the defense bar and the courts and the public that this was a sincere undertaking, so that we could help units actually that were having problems with that in other jurisdictions learn how to build themselves, how to make themselves credible, and how to do the good work that the conviction review unit was designed to do. So we looked at 21 of the first 25 of them. We're currently working with about 20 more jurisdictions because, as you'll see, these things have really become a substantial trend across the country. So the first unit was started in like 2004, 2005. You've got San Diego and Dallas both kind of vying for it. As a Philadelphia Eagles fan, I think it's clear that San Diego was first, but there may be some people who give Dallas some credibility. But 2004, there was one. When we did our study in 2015, there were 25. There are 68 across the country today. 68 jurisdictions have created conviction integrity units, and it's all happened in the last 15 years. And the trend is going up and up. More and more jurisdictions are saying, okay, why don't we have one of these? All these other jurisdictions have them. All these other jurisdictions think they're valuable. They have tended to arise in urban areas. So, you know, Philadelphia has one. New York has, I think, 4. Texas, as you can see, New York City, I think, has 4. I think they may actually, all 5 boroughs may have one. I don't think Staten Island has one, but I think the other 4 boroughs have them. They've tended to come up in urban jurisdictions, and that's true for a couple of reasons. One is there are more cases there, so that it's more likely you're going to have errors. And 2 is those offices have more attorneys, so it's easier for them to set aside a number of attorneys and say, you guys are going to process these petitions and investigate these cases and figure out whether we have errors in here. You know, 75% of DA's offices around the country have 3 or fewer DAs, and so it's a real challenge if you only have 3 attorneys in your office to say somebody's going to be dedicated to these, and it's probably less likely that you're going to have a lot of petitions because you're simply dealing with fewer cases. But we are seeing them in more suburban counties are starting to do them, and we're seeing a rise in statewide units and a model of sort of county share. So what I would mean by that is, so Pennsylvania, for example, Philadelphia has a conviction integrity unit, and we're seeing Center County, which is where Penn State is, which is a much smaller county, has established one more recently. So you're seeing that kind of trend from Center County is not really an urban center, but they're have enough cases and they're concerned about this, so they've created a process to review these cases when they happen. Pittsburgh doesn't have one. Pennsylvania has been described by some as Philadelphia and Pittsburgh with Alabama in the middle, and it has sort of a large rural component to the state, kind of in the center of the state. And so the Attorney General in Pennsylvania earlier this year announced, excuse me, a statewide conviction integrity unit, because he's concerned that we might have plausible claims of wrongful conviction in Erie or in Lackawanna County or in Altoona, right, that Philadelphia doesn't have the jurisdiction to look at. So he's going to work out those jurisdictional issues with his DAs, but he wants to have people who have a familiarity with how to handle these things and a process that works in case there are cases that come up in areas that aren't covered. Thank you, Judge. Yeah, North Carolina has a state commission as well. Actually, it was created pretty early on. And so this was a legislative act of the North Carolina legislature to actually create an agency called the North Carolina Innocence Commission. The way that agency works is they have a full-time staff. They take in these petitions, and then they actually go and have subpoena power to gather all those documents from whatever county the plausible claim of actual innocence arises from. And if they believe that, in fact, the plausible claim of actual innocence is meritorious, they can then go to a hearing. The DA's office in the jurisdiction where the claim has arisen can either support or oppose that, and a hearing is held, after which a resolution of the claim occurs. And one of the great things about North Carolina is because it's a legislatively created commission, they actually are then required to release data on that. So every year there's an annual report that they present to the legislature on their activities over the course of the year. And as you'll see, I think that transparency is a really important thing in reassuring the community that this is an actual well-intended, good faith conviction review process. There's
Professor,
yes.
Professor, can I ask a question about North Carolina?
Sure.
Because I looked at their webpage and the stats that they have on there, and I don't claim to be a statistician, but I was frankly surprised, given the resources that the commission had and the authority that it had, that it really was exonerating, or whatever term they were using, basically one person per year, which just struck me as a low number given what we know about wrongful convictions. And I just wonder if you've looked at that, or if anyone's looked at that, and I don't know what the right number is, but that just struck me as a lot of resources that really did not yield a whole lot of exonerations.
It's hard for me to answer that, not knowing the ins and outs of the cases. I think what I would say is one of that their rate has changed from year to year. What you might see is there are a number of cases that might be thought of as kind of low-hanging fruit that you look at right away. There's always sort of an ebb and flow to the petitions. With most conviction review units, and I would imagine North Carolina is no different. What we were seeing when we did our survey was when a review unit gets announced, there's lots of petitions. People send all sorts of petitions, and you kind of wade through and figure out which of those are plausible and which ones you're going to investigate. And then every time you have an exoneration, right? Every time you act on one of these and say, we did get the wrong guy, then you get another swell of people who want their cases to be reviewed, and then you work through those. So one of the things that we've seen is some of these easy, more blatant ones, we find those early on, and then hopefully, it tapers off. But a lot of it also has to do with what the rules are for the claims that you look at. So for example, if you were to say, we're not going to look at claims where somebody has pled guilty, well, you've just taken 97% of your criminal cases and said they're not eligible for review. I don't think North Carolina has done that. I'm just using that as an example to say the policies for case intake are going to control the rate of exonerations that are going to come out, as are the petitions that get filed, and then how those cases get managed. And, candidly, you can have a process, and again, I'm not saying this about North Carolina, but it is possible to have a process that is not a good faith process. Philadelphia rebooted its conviction integrity unit. The first unit, as you'll see, we have a checklist of 36 things that we think a good faith unit should do. At the time we did this, no jurisdiction was doing all 36 of the ones we liked, right? Nobody was perfect by our metric. But the unit that we thought was best had 33. At the time we did it, Philadelphia was doing 3 of those 36 things. It just wasn't a credible process, even though they had the unit. So you get that spectrum of quality, and it's really important that if you have a conviction review unit, you set it up in a way that people have the transparency and the faith that they're actually doing it properly, so that you don't have a concern about the numbers like you just raised. And I see Mark Godsey's added a comment, which is a useful one too. So in addition to the commission, the innocence projects there have exonerated many through the court systems in the old-fashioned way. So the commission is not the sole source of exonerations in North Carolina.
John, there is a question from Douglas DeMolt above Mark Godsey's comment.
Oh, I'm sorry. Let me scroll up. And the way the chat window works is I sometimes can only see the most recent one. Given limited resources allocated to prosecutors and public defenders in Ohio, Do I have an opinion on whether it makes sense to allocate additional resources on the front end to prevent wrongful convictions versus after the fact? So as you'll see when we get in this, what I would advocate for, I assume that everybody is already trying to prevent wrongful convictions on the front end. And so, yes, I would advocate for us to do whatever we can do from what's known about errors to allocate those resources to prevent things at the start. Obviously, that's a great thing. Part of what we do, the reason we do our Sentinel event reviews, is to give guidance to jurisdictions on where those resources can or should be directed in ways that we know are going to be useful, because we know that they've contributed to past exonerations. And so part of a way to get buy-in on what the reforms should be is to look at the cases that we know we've had errors, learn from them, and use those errors to try to prevent their recurrence. And over time, we think that's sort of system of continuous quality improvement is something that will reduce the number of these cases going forward. So yes, we absolutely should make sure that best practices for eyewitness identification, that best practices for interrogation in ways that minimize false confessions, that we enhance both the generation of forensic evidence and how it gets admitted in court, that we use, all of those things. I think we absolutely should do that. But those things happen now, and we still have errors. Conviction integrity units are places where we ought to be able to identify these errors. And because they then are in the DA's office, the DA is in a unique position to be able to gather all of the people in the jurisdiction around and say, let's put blame aside, let's figure out why this happened, and let's all do things together to prevent these things from happening that we all contributed to. And so that's where we would put resources as well. Okay, so I mentioned this, the statewide unit is a trend that's happening. We're seeing it in Michigan, where there's sort of concurrent jurisdiction, and the AG and the individual jurisdictions decide who's going to take it. New Jersey and Connecticut, a statewide conviction integrity unit is actually pretty easy to do because they have appointed prosecutors, so they all report up to the AG. So the AG just adds that to the office and then applies it to the whole state. And in Pennsylvania, if there is a conviction integrity unit that exists, they'll take it. If not, the AG can come in with the permission of the prosecutor and deal with that. And then in a couple of places, we're starting to see county sharing. So 2 or 3 counties together will agree to pool resources so that they've got somebody who's available to do this for all of the counties when each one of the counties might not have the manpower necessary to do it. So there's lots of different ways to structure it. And what's more important, I think, are the underlying sort of independence, flexibility, and transparency. So when we looked at the units that were effective around the country, this independence, flexibility, and transparency were the things that we found. And units are really trying to balance a lot of things. They're trying to balance due process and actual innocence. They're trying to balance, with transparency. One way to have transparency is to have people from outside the office evaluating the process in some way, shape, or form. Different jurisdictions have done that in different ways. We could have external people assist in the review of petitions to decide which cases actually we're going to investigate more thoroughly. We could have external participants help us in establishing our policies and procedures so that people believe we're doing this, in good faith. We could have external participants actually assist in the reviews or in our assessment of whether or not we should act on a case once we've completed our investigation. And different jurisdictions involve external participants in this in different ways, but the goal of some sort of external, contributor or participant, which might range from, in Jacksonville, State's Attorney Melissa Nelson has a 20-person advisory board that helps to evaluate what the appropriate action should take at the conclusion of a negotiation. In Lake County outside of Chicago, the prosecutor there has a 6-person grouping of all people from outside the county to reduce any concerns of political bias or political management in a particular system. But all of these are done to convey to the general public that it's not just the fox guarding the hen house, right? So the idea of the transparency is to make sure that the office has credibility, because there is a bias towards skepticism of these units, and balancing these things so that you're not a publicity stunt, but instead being looked at in good faith. Having written policies and procedures is another one that, these are areas where you can provide evidence of the independence of the decision-making process, the flexibility of taking as many cases in as you can because all these cases look different, and the transparency of showing your work so that the jurisdiction and the citizens in your jurisdiction believe that you are a conviction integrity unit in good faith. All of these are then the hallmarks of a unit that is effective. And I would say, when we published our report, I had a lot of reporters call me and say, well, the best unit is the unit that's exonerated the most. Who's that? And my response to that was, is it? It's not clear to me that the number of exonerations is necessarily the metric of success. We were talking baseball a little bit before we started. And what I would say is I would argue that the number of exonerations that a conviction integrity unit generates is a little bit like a pitcher's won-loss record, which is to say good pitchers generally win more games than they lose. But there are a lot of reasons that a pitcher might win or lose a game that don't really have anything to do with whether he is a good pitcher. Right? There are a lot of things that can happen in a conviction integrity process that you might not have a lot of exonerations because you might not have very good petitions. You might have it because, statistically, the petitions you get just don't lead you to cases that you actually believe were inaccurately decided. That doesn't mean you have a bad conviction review process. That said, if you look at Brooklyn, if you look at Dallas, if you look at now Detroit, jurisdictions that do have a lot of exonerations, and you look at the list of things that are in our report, you will find that those units do more of these things. So, the Brooklyn unit actually got started because they realized that they had a homicide detective in the 80s and 90s who had been involved in hundreds of cases, and many, many, many of those cases were now coming up as cases that had been mishandled and mismanaged. And so they actually created their unit to go back and look at all 500 cases that homicide detective had been involved in his career. They started with a pool of cases they believed might be tainted, as a result of which they were able to generate a large number of exonerations. Other jurisdictions who don't start from that position aren't going to exonerate as many people in that span of time. Does that mean that they're not doing it in the right way? Not necessarily. And so I think it's important to realize that exonerations are an indicator of quality, but not necessarily the only one or even the most important one. Questions there? Okay. So in our review, we talked about a desire for structural independence for these units, meaning that we want the decisions to be made independently of other things going on in the office. So the first thing is we recommend having the conviction integrity unit report directly to the elected district attorney. The reason for that is multifold, right? One is if you report directly to the DA is making clear that it is his or her focus. This is an important thing. It reports directly to me. There won't be any other interference. And this is something that I want to do and we're going to do because it's important. Number two, if I run the conviction integrity unit and I report to the assistant chief of the criminal division, and the assistant chief or the chief of the criminal division don't really believe in the conviction integrity process, well, there's all sorts of bureaucratic things they can do to minimize and mitigate any of the work that I'm going to do. By having it go directly to the DA, we solve all those problems. We make sure that the unit has the resources that it needs. So making sure that the leadership is behind it, making sure that the supervision of it is the right people. So you want somebody in that office who has credibility with the line prosecutors, somebody who knows that this is not just because somebody files a petition means this person should be have their conviction overturned, right? We're going to give this a critical eye. We think it's a plausible claim, and we're going to investigate it anew, and we're going to do it the right way, which doesn't mean that we have a bias on either side. Having when Brooklyn created its unit, they took a guy who'd been a prosecutor in the office for 25 years that everybody knew, everybody respected, not a pushover. They put him in charge of the unit. I asked him at one point, how do you know if you're winning, right? How do you know if people are buying into this process as a legitimate process for actual innocence, as opposed to some sort of let's just let everybody free and overturn all our old convictions? And he said, well, the way I know is that when I started, I had to force people to come work for me in this unit. Now, when I've got a vacancy, I have 12 people from the office raise their hands and ask to participate, because they see the value of what we're doing and they see that it actually makes us better prosecutors. So making sure you've got supervision It's people who are willing to look at these cases from the perspective of, do we really think this claim is plausible? How do we prove or disprove that? And people who have credibility from within a DA's office ends up being really important. And then again, these external stakeholders, the external stakeholders are there to provide additional eyes, additional thoughts, additional experience on how the office, how the unit is managed, and whether we're investigating things thoroughly, and often investigating things not necessarily using a prosecutorial mindset, but using almost a defense mindset to say, do we believe this person is innocent? How would we prove that? And so having the unit work with people who have an experienced defense perspective can be valuable, because if you've been working in a prosecutor's office for a long time, you're going to look at cases a particular way. Making sure that you're kind of being a 360 view on this is a valuable thing, both for the cases themselves and, again, for the external perception that the unit is operating openly and properly. Flexibility in terms of the cases. These cases are cases that generally don't fit in the typical post-conviction system for one reason or another. Maybe all the appeals have been exhausted. Maybe the evidence was ruled not newly discovered and therefore hasn't been able to be assessed, but now it's there. We're looking at a case now in Philadelphia where there was actually a blood test that was dispositive. The blood test was completed 2 hours before the jury returned its verdict, and it took 18 years for the Pennsylvania post-conviction process to actually be able to incorporate that blood test into the case, and the individual was then set free. Obviously, that's not a result we want. Having the evidence there, and for whatever reason, and there are many, many reasons that we're just beginning to get into why it took that long, but these are cases that, for whatever reason, haven't fit in a post-conviction setting. And being flexible about that and saying, look, the key question is, with all of the information that we've gathered, not looking at this as an appellate court, but looking at it as, you know, criminal justice professionals and observers, with this data set, do we think that this is a plausible claim of actual innocence? If so, the whole point of this is not to let procedural challenges get in the way of that fact-based investigation. And since cases can come from all sorts of places and in all sorts of postures, we would recommend, for example, that you not say that a case where the person pled guilty is necessarily rejected from the review. But let's be open to that. Let's see, yes, I know you pled guilty. That's definitely something I'm going to want to understand. But is there a plausible claim for actual innocence? Can you explain that in a way that I think has some substance? If so, yeah, we'll investigate it. And then we'll talk to you about it. And if there's a point at which we say, we don't think anymore that this claim is meritorious, we're going to hand it back to you and we're going to put our pencils down and stop work, then that's going to go in a parking lot. And if you come back and you resolve that problem that we've got, that reason why we think it was no longer a plausible claim, then yeah, we'll revisit it. But now it's on you. We've given it our review. Here's what we think about that, and we'll go from there. And so, being flexible in the procedures, the procedural postures of the cases that you review is something that we mention in our report as well. And then there are questions about case eligibility, and this is something that I think units around the country are beginning to kind of move outside of where it was in 2016 and begin to test some things. Your mileage may vary, okay? So what seems to be universal is a plausible claim of actual innocence is something that we want to review and we want to look at. Most of the jurisdictions that we look at will do so based on a totality of the circumstances, and they won't be very picky about newly discovered evidence. So they're looking at all the information known today, which may or may not be information that was known at the time of trial, okay? But they're willing to look at it now with a fresh lens and make that decision. Some of the units we looked at would actually apply similar due process rules, and if something was known at trial, they would discount it. That's a minority view, but it does happen in some jurisdictions. What we're actually seeing happening now is that pretty much everybody is on board in conviction integrity units around the country on this sort of totality of the circumstances view. Now we're seeing some units, and Philadelphia is one of these, that are beginning to look at not necessarily cases just of actual innocence, but they're beginning to use the conviction review unit as a place to bring cases in where they feel that sentences are dramatically different than sentencing policy is today. So if 20 years ago we would have given a 40-year sentence to somebody for armed robbery, and today that sentence would be 8 years as a matter of guidelines or policies or practice, we're seeing some units take that forward and say, we want to let this person out on time served, because had that person committed the crime now, they wouldn't have gotten anywhere near the sentence, and we can demonstrate that in some sort of objective way. Candidly, this has been getting mixed views. There are not a lot of units that are trying to do this, but it is a trend that we're starting to see as more and more jurisdictions are interested in reducing their rates of incarceration. And there are areas where people feel that there are, objectively available and accessible miscarriages of justice that people in the jurisdiction can get behind. So it is an emerging trend. It's not something I'm particularly expressing an opinion on now, except to let you know that it's something that you might want to consider. And if somebody were creating a conviction integrity unit today, I would recommend that they have a policy on whether or not they're going to limit themselves to these fact-based cases of actual innocence, or also go into that context as well, which I think might have some ramifications for obviously for the cases that they process. And I've talked a lot about transparency, but just to mention it. So first of all, I think there should be transparency with the petitioner. So there are different ways to do this, but in essence, there's always a possibility that you're going to generate new evidence during the investigation. Figuring out how to handle that, because the evidence might be supportive of the claim of actual innocence, but it might also be contrary to the claim of actual innocence. And that's always a possibility when you're looking at these cases. Making sure that you show your work, right? This is what we reviewed. Based on this, we don't believe that you have a plausible claim of actual innocence because X, Y, Z. Doing that for the petitioner and doing that for the good of the unit is a way of making sure that these claims are being taken seriously, and that there's an opportunity for that back and forth dialogue in case we, the reviewers, have missed something, which sometimes happens. The defendants and their attorneys often have resources, the ability to get to certain witnesses, certain other information that the prosecution or the review unit might not have access to. And this back and forth allows for the real goal here, which is putting aside the kind of strictures of the appeals process. Are we really getting to the truth? Explaining what our policies and procedures are, that's funny. So one of the units that we thought was the best, one of the best in our review, we made a big deal about written policies and procedures, and that unit said to me, I'm not going to do that. The reason I'm not going to do that is that I actually want the flexibility to deviate from this in cases where I think it's necessary. I don't actually want to set myself up for a contract dispute if I've gone outside of my policies and procedures. So in furtherance of the flexibility point, they were deciding not to be quite so transparent. My personal view on that is, you've got enough talented lawyers in Ohio that you could write policies and procedures that give you room to have that flexibility while also being transparent about how the unit conducts its business. And I think that transparency on these are cases we'll accept, this is how we're going to manage them, these are the rules, is a really useful thing to the community to understand how we handle cases that are in these thorny areas. And then I think we should take credit for the good work we do. I think we should share the activity and the metrics. We should use that data to think about how we staff these, whether we expand them, what other cases we should be taking, or whether we think we've got, we're doing what we should be doing. And I think that data on effectiveness and thinking about what those metrics ought to be is an important part of the process to make sure that we're getting better and better at this and handling it with the appropriate efficiency. Brady is a big deal in these cases. It may be a big deal because it happens, but it's almost always alleged. And an allegation of Brady and existence of Brady are not the same thing. And existence of Brady and intentional mishandling of evidence are not the same thing. One thing that we recommend is that the Conviction Integrity Unit not be investigating allegations of Brady, okay? The Conviction Integrity Unit is there to process and address petitions of actual innocence that have some credibility to them. It is not your disciplinary group. And you don't want to muddy the waters. There's going to be enough internal office suspicion of a prosecutor in your office investigating a previous case from one of your other attorneys to not then also make it the disciplinary group. So there's already a process for handling Brady allegations in your office. If your conviction review unit, conviction integrity unit identifies an instance where we might have had a Brady violation, that Brady violation should be identified, and made public within the context of the case, but it should also go over to whatever your existing process is for reviewing those. Let them handle it. The conviction integrity unit should be free and clear of that so that it doesn't create unnecessary friction in the office or muddy the waters on what the purpose of the conviction integrity unit is. We also recommend, by the way, that let's say that Judge Zamuda and I both are working in the office. I work in the conviction integrity unit, and I've been given a case where Judge Zamuda was the prosecutor 15 years ago. We would want to interview Judge Zamuda. We would want to understand why he believed the conviction was appropriate and righteous and obtained in good faith, but we would not want Judge Zamuda to be leading that review. The conviction integrity unit should do that separately. And the original prosecutor is there for useful facts and information and understanding, but is not ultimately the person who's going to be making decisions about how we handle that case for obvious reasons. So that having those ethical walls, if you will, or separation of purpose around the conviction integrity unit is a way of preserving the integrity of that process. There are some other policies that might facilitate conviction review. I don't know in Ohio, I apologize, whether lawyers have the ability to petition and judges have the ability to toll a case that's currently going in a post-conviction review process. But if possible, if the conviction integrity unit, which should be outside of the appellate division, right? So one of our recommendations is the unit should report directly to the elected and not be part of the appellate division. The appellate division is trained as a conviction preservation unit. That's what it's there for. There's lots of great reasons for that. That's wonderful. But if your perspective is every case I get, I'm looking for the procedural reasons why this conviction should be sustained, it's difficult to also ask those people to look at plausible claims of actual innocence and almost completely flip that around and start looking at fact-based reasons for innocence. That may mean that you get a petition in your conviction integrity unit for a case that is currently proceeding through the appellate system. The deadlines on the appellate system might not enable the full investigation that you'd like to do of the facts. So an opportunity to toll the current appellate proceedings while the fact-based investigation goes forward is a useful thing for the fullness of the fact-based investigation, and it does not then taint the appellate process. If the conviction integrity unit comes back and says, we've elected not to proceed, then you go back into the appellate process. And let's be clear, there are really three possibilities from any conviction review process. One is, we agree we think this person is actually innocent, and we're going to figure out what we can do about it. Two is, we disagree, and we're not going to do anything about it. And three is, we're going to agree to disagree, and you should go to the appellate process. That's what that's there for. But we're not going to pursue it as a conviction integrity unit. And so we're not, the units would then toll current proceedings in the post-conviction process and resume them if and when the conviction integrity unit decides not to proceed with a case. One of the things that some groups do, so engaging petitioner and counsel and the collaboration agreements kind of go together. So one question is for the unit is, to what extent do we work collaboratively with petitioner or their counsel as we're doing this investigation? There are units that would say, well, we're going to treat this the way we would treat any other investigation, which is we're going to go do it, and then we'll come back and we'll tell you what we found. There are other units that say, well, we think you can help us with this investigation. We'd like to get all the information you have. You need to share everything with us, and then we'll work together and kind of talk it through. One way that has been handled is with collaboration agreements. So basically, what one unit will do is they'll say, here's a contract. The contract is a confidentiality and collaboration agreement. And this involves how we're going to go through this together and ensures that neither of us interfere with the investigation by going to the media or doing other things. We're going to work together on this in a collaborative fashion. If you don't sign the collaboration agreement, we, the conviction integrity unit, will still investigate the case, but we're going to investigate it and come back and give you our conclusions. If you sign the collaboration agreement, then we'll work with you, kind of arm in arm and sharing information as we go. it's your option, petitioner, how you want to do this. So the ways that you engage the petitioner or their counsel can affect the way the investigation moves forward. And then another sort of question that's out there is whether or not, so from the petitioner's perspective, they're asking the prosecutors to review this again, and prosecutors will say, well, that's fine, but I need all your cards on the table. So I want you to waive any attorney-client or work product privilege that you have, and I want you to open all of your files to me, because if I'm going to do this extrajudicial review, I want to know that you're not holding anything back, right? And so this is something that defense counsel are crazy about, because they're like, you got to be kidding me. First, you wrongfully convict this guy. Didn't actually do it. And now you want him to waive his Fifth Amendment rights? Like, pull the other one. And it's an actual tension. And I can understand the arguments on both sides. Most jurisdictions have come to the conclusion that they're not going to ask for a waiver of attorney-client privilege as a prerequisite for participating. But not all units have made that decision. And that's sort of the back and forth and the debate that happens. I see I have a couple of questions, so hold on a second and let me get these. The departments that have these conviction integrity units, what have they learned that have helped them move forward to avoid repeating some of the same errors? Judge McIntosh, the answer to that is I think that's an area where all of these units can improve. I think that what we're not seeing is an integrated process of learning from these cases to move forward. We do see some things happen, particularly within the DA's offices. So to the extent the DA's office has policies or procedures that have contributed to an inaccurate conviction, they will sometimes make those changes. But in general, so just as an example, the eyewitness identification policies that I described earlier, those aren't within the purview of the DA's office to implement. We have to have police departments in those jurisdictions implement those. So unless you have a process that coordinates the DA's office with other organizations in your jurisdiction, there's a limit to the policies and procedures the DA, him or herself, can implement. But the other thing is that we don't see a defined, repeatable, cyclical process of learning from these cases. And that's exactly where we'd like to see Conviction Review Units 2.0 go, is to not just process these cases, but then actually have a separate process for the kind of blame-free reviews that we've done that figure out the holes in various slices of Swiss cheese and work to close them up. How do appellate prosecutors and appellate courts take to the idea of a motion to stay the appeal pending CRU review? So I guess the way I might say that is, at least when I'm teaching in law school and I've got 10 law students lined up in front of me, if I ask any of them a question, I'm going to get 12 different opinions. Different people view this differently, but in general, the philosophy is we're not harming the review, the appellate review, by tolling this proceeding. What we're doing is we're saying, let's take a pause because a plausible claim of actual innocence has been raised. And that plausible claim of actual innocence, if accurate, is important enough that we think it's going to interrupt this whole process. So let's not spend time on the appeal yet until we've decided whether or not we're going to proceed with this larger issue of, did this person actually do it, which we think trumps the issue of, did this person get a fair trial, right? So I'm sure there are people who say, we shouldn't give these people another hearing, and finality is a necessary policy, and people are going to draw lines in different places there. But in general, the idea is that the higher purpose of actual innocence is what justifies taking a pause, and you're not harming the appeal. There are a million different fact patterns, and I'm sure that, and procedural patterns, and I'm sure that people could come up with examples and stories in their past where that wouldn't necessarily be the case. And again, that's why we want these units and people experienced with these to kind of talk these issues through and figure out the best result for an individual petition.
Professor, could I just ask you a quick question?
Sure.
Because you followed up, or I'm following up on the last question, which was mine. One of the things that I'm wondering about, though, is this. If I'm an appellate prosecutor and I'm asking for a stay for this, I'm concerned that it is sending a message to the Court of Appeals that maybe we got the wrong guy, that's going to put a thumb on the scale of the appeal. And if I'm a defense appellate attorney and I get that stay, and then the conviction integrity unit comes back or review unit comes back and says, yeah, there's no problem here, keep on going. I'm worried that a court of appeals might say, oh, well, as long as we've got a secondary review on this, maybe that sufficiency of the evidence claim isn't all that important after all. Does the CRU review running parallel to an appeal cause you concern about the integrity of the appellate outcome?
It doesn't, although I think it's important to have that be a known thing. In other words, I think as lawyers, we all understand the difference between a fact-based review and a due process-based review. And I think we all understand that the obligation is to handle due process without looking at whether we believe the person, the facts are what the jury has said they are, unless and until another trier of fact reaches another conclusion. So I think all the time we're applying appellate rules and due process rules with an eye towards making sure we got a fair trial. And not with an eye towards whether or not the person is actually innocent. And so it seems to me that if there is a pause for a conviction integrity unit review, and that conviction integrity unit then comes back and says we can proceed, I wouldn't say anything more than that. I certainly wouldn't want to express an opinion one way or another, but there are a million reasons why the unit might decide not to move forward with it. And then I think we have experienced appellate lawyers who understand the difference between due process and others. If you had a claim for actual innocence that was being pursued, then maybe I think there's some risk for overlap, but I think our appellate attorneys and our judges understand how these procedures work well enough that I don't think there's a real risk of bias, and I think they'll apply the rules honestly and fairly. I think one of the hardest parts of this for any conviction integrity unit head and any elected is what to do with a case where you really don't know. There are going to be cases where you get a new DNA test and it's just obvious, right? The DNA comes in, we're retesting it. It's not the individual we thought it was. We get a hit. We know exactly who it was. They match and they were there at the time and all these things. Those cases are going to be easy. There are also going to be cases that are the reverse where we do the DNA and you know what? It was the right person. I have Adnan Syed and the Serial podcast, which I assume most of you are familiar with from a few years ago. Not here because I'm taking an opinion on Mr. Syed's guilt or innocence, but because at the end of this deep review that the reporter did, her conclusion was, I don't know. I like him, and I don't think that the case really is that strong, but there are definitely reasons why he's connected to this, and I don't feel like I'm really getting everything that I know, and I just don't know what to do. And in the conviction integrity context, we're still going to have that, right? We're still going to have cases where it's like, well, would I have brought this case and charged it knowing what I know today, right? Knowing what I know today, do I think this person did it? And how am I going to process this? Or am I going to say, well, there's nothing that is clear and convincing to convince me that we shouldn't have done what we did, and so I'm going to trust in the system. And the rationale for those decisions are something that the individual prosecutors will always have to deal with, just like they have to deal with those in cases today when they decide whether to proceed with charges in cases where we don't know what we don't know. And so these are going to be agonizing decisions because there are going to be cases in the conviction review process where it's not necessarily conclusive evidence of innocence, but we really don't think that the conviction that we got was all that great. And maybe we wouldn't have brought that case if we had to do it again, knowing what we know now. So how do we handle that? That's really going to be up to the elected, but I don't want to suggest that a conviction integrity unit is itself perfect, right? Humans are going to be involved, and these decisions and the rationale for these decisions, when you get into these tough gray areas, that's going to be different and needs to be sort of thought through. We need to have a philosophy, but there are different philosophies that I think can be reasonable and applied as long as we're doing so equally and fairly. So you guys have the report. I'm not going to spend a lot of time on this, but these are the checklists that we have. These are ways that we've seen that are objective and can be looked at openly to say, again, no unit necessarily has to do all these things, But in general, the units that do more of these things have better relationships with their jurisdictions, with their defense bar, and with the attorneys in their offices. And they tend to be the units that people look to and say, that unit's doing it the right way. So there's a lot of these, but you can look at them and measure them. And they're there to allow units that are there to think about how to improve, units that are getting created to think about how to structure themselves, and people who are evaluating those units to kind of give them a way to look and see how the units are doing. So these are issues that we're working with. I said we were working with about 20 plus jurisdictions with conviction integrity units around the country. As more and more units get these, or as more and more units are formed, more and more issues are arising. So issues of internal conflicts, which department should be looking, should the conviction integrity have this or the appellate unit have this? If we have a DA's office that handles both civil and criminal cases, do we create a conflict where conviction integrity could actually lead to litigation that our civil unit has to do, and how does that get managed? Things like that. How do we communicate with pro se applicants? Do they really, if we communicate with a pro se applicant the same way we would communicate with a defense counsel, are we really communicating in ways that can be clearly understood? And are we really giving that applicant a fair run through our process? We mentioned the jurisdictions for, especially smaller offices and more rural jurisdictions. And increasingly, what we're seeing is some units turn to law schools and law students and other volunteers to help process petitions and help look at them and decide whether a petition should move forward into a full-fledged investigation. And obviously that's something that you want to do carefully and thoughtfully as well. So we are seeing lots of other issues continue to emerge, and that's going to continue to be the case. So I guess this is my sort of last slide, and in response to Judge McIntosh's question, we think that conviction review units, conviction integrity units, and by the way, the term is interchangeable. There are units that say, we think all our convictions already have integrity. We don't like the implication that we are not operating with integrity, so we want to go with conviction review units. As a result, we call them conviction review units in our report because I figured, why get into that fight at all? I seem to have lost that fight, and more of these units are calling themselves conviction integrity units. But either way, the underlying purpose is more important to me than the label, and just so you know that conversation has happened. But what we'd like to see these units do is not just the great work that they're doing to remediate previous errors. We'd like to see them be the unifier of a system-wide review after all of these cases to prevent the next error and the error after that. Honestly, I think you'll save yourself a lot of money if you do that. The civil litigation that happens in these cases is often in the tens of millions of dollars per case. Better to spend a few $1,000s doing a review now than $20 million when an error is discovered X years down the road. So we think it's good policy for any number of reasons. And so that's my presentation for today. I'd be happy to answer other questions, and I'm of course always available to you if there are other thoughts or areas that you'd like to explore in the work that we do.
All right, John, thank you very much. Let's keep your slides up in case we have questions that want to refer back to a specific slide for the moment. Let me ask this question, because I don't know how much you know about Ohio. We are, I think it's fair to say, the antithesis of a unified system in terms of our courts. We have 88 counties. Each county is its own system, and we have a state in which the people within each of those counties view the county as their own. You know what I mean? So we have 88 common pleas judge courts, 88 prosecutors. And I'm curious the extent to which you have studied the ability for CRUs or some other method of review of convictions is impacted by what I call the home rule. All right. And that is the sense that we will guard our own, and we're not really concerned about statewide. We just need to manage our own affairs. And whether or not you've studied that issue, number one, and if you have, the extent to which some of your recommendations might be modified or affected as a consequence of that what I call the home rule phenomenon.
Well, so I guess what I would say is it's a barrier to criminal justice reform across the country that our criminal justice systems and subsystems are so fragmented. There are, I think, 8,000 counties across the United States. Many of those counties, Montgomery County, Pennsylvania, which is where I live, has 55 police departments. So you want to implement a reform, best practices in photo IDs, you got to do it in 55 departments. You want to gather data to try to compare how those departments do things. You got to get 55 different IT systems to generate data. And so, the challenge of implementing reforms and how you do things is the fragmentation of the criminal justice system is a problem everywhere. The practices that we outline here for conviction integrity units, we think are equally applicable in Texas and Tampa and San Jose and Kennebunkport. It's then a question of how you apply it within the rules of your jurisdiction. So if the rules are, in Florida, where you literally you can't toll a post-conviction appeal, nobody has the power to do that. Well, now we're going to have to figure out something else to do that allows a fact-based conversation to proceed in parallel with that appellate conversation. And that's, so the issues get influenced by the rules in your area. But I guess in my mind, it would be great if you, a couple ways you could do it. You could say, okay, we're going to give the Attorney General jurisdiction for these cases over all 88 counties. Or you could say, we want each of the 88 counties to do so, and here's how we should do it. Our report kind of takes that second route because, I have no authority over anybody anywhere. And so we're recommending a path to that whether you have a statewide unit, a countywide unit, we think these are the underlying philosophical underpinnings of a strong, good faith conviction review process in ways that acknowledge some of the psychological challenges that you have with the people in your own office when you're investigating previously secured convictions, and that acknowledge the skepticism from outside of the fox guarding the hen house. So we wanted to explain it both from a philosophical perspective, but also from a realistic, like, how do you really get this done, knowing that people on both sides aren't going to trust the process? Mm-hmm. And I think that's true across those counties. And then you just hope that you have people who pursue it in good faith. There's an acronym that was coined, not by us, but by other people who don't trust some of these conviction integrity units. They call them CRINOs, which is conviction review in name only. And you want to avoid somebody sticking that label on you of being a CRINO. You want to, in some ways that does more harm than not having a unit at all, because it undermines, confidence in the system. And so I think if you have 88 counties, my guess is that you'll have some bell curve of people who are really enthusiastic about this and people who really hate it. And you would hope that whatever the system is, that they get behind the process and the philosophy and do it the right way.
All right, thank you, John. Other questions for Professor Holloway? Anyone? Maybe we can take you out of your PowerPoint. Sure. Get back to the generic screen. There we go. Anyone else have any comments, questions relative to his presentation? I don't see any, so I want to thank you, John, for your time. We're going to continue with our meeting now. You're welcome to stay in, but I know you're busy. You got a class later today, right?
I do, yeah. So I gotta run, but I really appreciate your time, your attention, the thoughtful questions, and really just your willingness to engage on this topic at all. I think is a service to the community, and certainly something we appreciate, and I'm sure all of the folks in Ohio do as well. So thank you very much for letting me be here. And if I can be helpful to any of you going forward, please don't hesitate to reach out.
Well, on behalf of the task force, I want you to know you already have been immensely helpful with the time and the report that you've provided, giving us a framework. We've just begun, this task force has just begun its work, and it was important for the task force to hear somebody who has the reputation and sort of the breadth of knowledge of what exists already out there in the United States relative to this issue, to come and give of his time and present to us and give a really thoughtful presentation. And I just want to commend you in the presentation and the slides that you presented that we now have, and will I think will clearly enable us to expeditiously proceed in the work that we've been tasked to do going forward. I thank you kindly, John. And I'm sure we will be in touch. Anyone else before we let them go? Excellent. Thank you, John. Take care.
Okay. Thanks, everybody.
Best of luck. Okay, so are there other questions that we want to talk about at this point, or people want to raise in light of his presentation? Because we're at number 6. It says discussion of John Howay's presentation. When's lunch? Is that the next idea? Did we find it helpful?
It was great. It was very great. I thought it was very thorough and very, gave us a lot of different information and a lot of perspective. I thought it was a wonderful presentation.
I would agree with that. So some of the, he teed up a couple of issues that I think we need to confront. I think he gave a breadth of what other communities have done, jurisdictions have done. This tolling issue is interesting, perhaps because I am now an appellate judge and I'm mindful of it far more than I was when I was on the trial court. But that is what he suggested is it's almost the reverse of what I see typically happen in Ohio presently. What was the other? There was one other issue, well, more than one really, but the extent to which changes are within the existing structure versus creating new structure to provide a framework for eliminating the error. And I like the approach of not just looking reflectively back and saying, yes, an error occurred, but in saying, as a consequence of that error, how do we prevent it going forward so that it doesn't reoccur? And I really think setting up a mechanism or framework of recommendations to creating error-free prosecutions and adjudications going forward should be mindful of the work we're going to do, not just how do we capture the errors in the conviction of somebody wrongfully looking backwards. So, and I think that pull probably compels our work going forward. Anyone?
Your Honor, if I can follow up on
John, go ahead. Yes, please.
Thank you. One of the things that I think we need to think about here is that as maybe a primary question is, what do we mean by a conviction that lacks integrity or a wrongful conviction? If the trial were inherently unfair, but the guilty guy was convicted, the defendant had actually done it. It seems to me that under the professor's rubric, that doesn't count as a wrongful conviction. And I understand why. I'm not questioning that. I'm just looking at it from the point of view of his baseline definitions and where he works from there. And obviously he's doing great work and very thorough work. My concern, though, is that if we don't address whether or not the process is working correctly, that we lose the opportunity to make sure that prophylactic is in place to prevent the wrongful convictions. If the process, if all we look at the end of the day is how many times did we get it right and how many times did we get it wrong in terms of did this person do it, and we don't look at the process by which we're getting there, I think we're going to lose an awful lot of those innocent person was convicted cases because we haven't been introspective enough about the process. I'm doing the best I can to articulate the thought that's emerging.
Is it fair to say that what you're doing is you're articulating a distinction between remediation, which is emphasizing the evaluation of conviction that may be wrongfully obtained, somebody who should not have been convicted but was, versus preventative, which is the obtaining of that wrongful conviction is perhaps a systemic problem that can be fixed, such that a future defendant accused of an offense would not be subject to the same potential wrongful conviction as a consequence of that systemic problem.
Yes,
And that distinction, I think, is significant. And that's what he was trying to articulate throughout, is to say you can't just look at the remediation. And I think, and that's what CRUs do, I think. You know, they have to. They have specific petitions and cases. But I think we have to look at it from the going forward preventative, because the reality is I'd love to have to be in a state where we have no wrongful convictions, right? I mean, Mr. Godsey may be out of business, but that's all right. I think he's bright enough, he'll be able to figure out what else he can do. And there'll always be work for Tim Young in making sure that there isn't a wrongful conviction, right? But I think we owe it to our constituents to be able to say, we know enough now, and there's enough experience across this country, that maybe we can modify our current practices. All right. And that's across disciplines. That's not the courts itself. That's not the prosecutors, not law enforcement. All right. But it's across system wide that maybe we can reduce the extent to which there may be 4 death row defendants who are innocent sitting there, right? So that we can say, no, we are more assured that there are 0. And if we are successful in creating fixes systemically going forward, just think of how much better our system of justice and the level of trust that people have, that if they have their day in court and they end up being convicted, all right, that the community can say and the state can say it was well and truly tried. That's a line we use as trial judges, right? We say to well and truly try that case. And that's what that means, I think. So, so I like that distinction. Go ahead, John.
Yeah, Gene, I don't know what your perspective is from the appellate bench, but mine is his point about we don't step back and look at the systemic problems. I mean, we look at it on a case-by-case basis. We may say there's error here, there's not error here, and then that's kind of our review at the end of the day. But I know my experiences on the appellate bench is I see problems that are recurring problems, and it's not just in the criminal context, it's in a number of different contexts. And I kind of sit there and think in the back of my mind, boy, someone should do something about this. But it's also, it's not something that I can really do anything about because it's not a case in front of me.
Right.
But I think that his broader point is a good one, is that we do need to take that step back and say, there are some systemic issues, and what should we do about them, and not have our tunnel vision of, all right, I've resolved this case, I'm going to move to the next one.
Right.
Yeah, Judge, I mean, I loved his analogy with the National Transportation Safety Board about how airline crashes, when the investigation, they find out what the problem is, and then they implement system-wide recommendations so that it doesn't happen again. It's not just that, okay, this is not going to happen on Delta, or this is not going to happen on United again. It's not going to happen throughout the system, because we've identified what a problem is to the system, and now we're going to make recommendations, and we're going to make sure that that problem doesn't occur anywhere else, which makes us all safer. And I loved that analogy, and I think that's something that we should take to heart.
Right. Thank you. Mark, go ahead. We can't hear you, Mark. Still can't hear you. It doesn't say you're muted, but for some reason,
Technology.
Mark Gotts cannot be heard. Isn't that amazing? Let the record reflect. I don't know what to say. Justin, do you have any help here? Or Michael?
You could try typing his question into chat, or a statement, depending on how long it is, then we could all see it.
Yeah, you want to try just typing it in, and then we can address it that way. Anyone else? Okay, so to that end, Representative Leland, in terms of how we can going forward from here as we wait for Mark's comments. Mark, are you trying to type it in or no? We'll just move forward. Let's see, I think you did type something. Mark, someone is suggesting you check your Zoom settings to see if your microphone is set to internal microphone or not. And you're trying to fix your mic. It's still not fixed. So it's 11:49. All right. So here's how I've kind of set it up as we can proceed organizationally. You have been provided the 50 state review and the post-conviction Ohio review. We actually have the 50 state review was created by two staff persons at the Ohio Supreme Court Library. And they're available if there's specific questions about what that report shows. And I want to give them recognition as to the hard work that they did. Michelle, thank you. And Rachel, there you are. Michelle and Rachel did an outstanding job, I think, in collating all that information in a meaningful way that I think it's digestible for us to utilize it as we move forward. And I wanted to give public recognition to the two of them for their hard work in creating that. If there are specific questions, they're here to answer them. Probably not, other than I think you all join with me in the great work that they did. Similarly, the Ohio Post-Conviction Review, Justice Donnelly, who is participating in this, but only audioly because of an unfortunate accident that he's recovering from and doing fine, is just unable to participate by Zoom. Anyway, he has two interns from law school who facilitated the creation of that post-conviction review for Ohio. Elliot, I see you, and I'm looking for, was it Joanna?
Jordan. She's driving right now, so she's only
Jordan. So, okay. Yeah, I want to thank you publicly for your work. Excellent job as well. Are there any specific questions about what that memo states, issues that it might have raised in any of your minds for further research that you would like us to conduct? I don't see any, so thank you, Elliot. I appreciate that. So what I think those will help, I think, augment and supplement our discussion for our next task force meeting. So the third category of information that we have not given back to you yet is the brainstorming ideas that you have given to us. And I am amazed at the quantity and volume and quality of those brainstorming ideas that you have each shared with us. And rather than be repetitive and just dump all of that on you, I think the best way that we should proceed, and what I'm choosing to do, is as follows. You'll see item number 7 is our next task force meeting is actually November 5, where we will spend the entire 2 hours or so discussing the brainstorming ideas. And what we're going to do prior to that time, and what we've begun the task of doing actually, is to consolidate and kind of frame all of these ideas that you all have presented to us in a meaningful way so that we can do it in an orderly or systematic way. And I think as we digest those brainstorming ideas, it will also create a framework of how we proceed with our work going forward. Okay? And I think as we do that, you'll see some of the issues that we heard John raise today, that we've talked about following his presentation, in terms of how we're going to go forward. I want to do that on November 5th because I'm really excited that I've been able to secure the appearance of Larry Krasner. He's the DA from Philadelphia. He's to say he's cutting edge on conviction integrity units is probably an understatement. And he has agreed to participate and give a presentation along with the head of his conviction integrity unit. Her name is Patricia Cummings. To keep the baseball analogy going, Patricia Cummings is the first pre-agent when it comes to conviction integrity work. She was from actually Harris County down in Texas. She created many of the conviction integrity units down there. She is a well-known and well-respected national expert as it relates to this issue. And after Mr. Krasner was elected as the DA in Philadelphia, literally went out and hired Ms. Cummings, thus the moniker, the first free agent in conviction integrity work. So, and she speaks nationally. Both of them have a national reputation. So it'll be interesting to hear their perspective about what they're doing within a CRU from a very progressive DA office. And it helps frame, in conjunction with what John just gave us, I think, sort of a national view. So that's November 19th, which is our standard every month meeting. And I think it's important that we keep the momentum of the ideas and how we're organizing going forward, which is why I've scheduled November 5 as our next meeting. I would like to take up this brainstorming idea. And then we would, after the November 19 meeting, then relegate back to a monthly meeting. I will let each of you know that we are not open-ended in the work that we're doing here. All right. If maybe none of you remember this or not, but when this task was created back in March, the chief had given us a 6-month window or 7-month window and wanted us to produce our report by December of this year. And obviously that date is no longer viable because we were unfortunately delayed as a consequence of COVID and an effort to try and sort of ride the storm in hopes that we could meet in person, which has proven to be unattainable presently. So, but we do have some time constraints, and I did ask the chief when she would like it, and she said, well, let's just extend that 6 months. So we're looking at a April to early May report time. So we have a little bit of time, but we do need to get on with the work that we're doing. And I think we're progressing nicely, especially with that brainstorming idea. I think once we meet on November 5th and review the categories of ideas, I think we'll make the decision, John, that will answer your question about, defining what does it mean wrongful conviction or conviction integrity, the categorization of cases for which should be, we should manage or not. We could make a decision that we're not going we don't need to do that. That will be left to the individual organizations that will be managing that, if that's what our recommendation is. So, but it's worth further discussion as it relates to that, I think. And then create the framework for going forward. I do think that this type of issue is so broad and there are so many specific issues that it probably calls out for the breaking up into subcommittees. We had some discussion of that at our last meeting. And I'm happy to report that Zoom technology allows us to do that breakout session within the context of Zoom, that we could do that going forward. We'll have more information about that. And of course, it's what the task force wants to do, whether or not they choose to want to break out into individual subgroups. It probably will help facilitate a more timely report than if we did this collectively with the entire task force addressing each of the items. But that's for further discussion and what we'll address on November 5. That's kind of where I see us headed. So I think the November 5th meeting is crucial to understanding the scope of the work that we're agreeing to undertake as a task force in making recommendations as a consequence of this review. And hopefully each of you will be available on that date from 10 to 2. Again, I'm trying to constrain our work within a 2-hour window because of everything else that we're doing and being mindful of your day jobs. All right. Questions, comments, concerns? Anyone?
Hey, Gene,
Judge Salvaggio.
can we get a copy of the pie chart slide that Professor Holloway had in terms of the
Ohio?
I don't remember if it was Ohio. I don't remember if it was Ohio or the national average.
It was national.
You're talking about this one?
Yes.
Which shows the proximate causes of wrongful convictions, procedural misconduct, other misconduct, that one?
Yes, that slide, and then the slide where he talked about it was the slide that had the actual innocence circle and then another circle, and they were intersected together, and it listed 5 different things with it said universal, actual innocence, and then made its way down.
You're talking about this one now?
No, it's one after that. Not to take up everyone's time, but yes, that one. I just wanted to compare those 2 slides together.
Ask not for who the bell tolls, Judge Savage, right? It's tolling for thee.
Oh, you can hear that too.
I can hear that, yes. So in any event, yes, all of the slides are actually available. And if you want, we can forward the slide presentation to each of you. We will put it up on the site on the Supreme Court so that people can see his slide presentation. He's given that to us. But certainly, Nick, we'll make sure that those 2 go to you. And if anybody wants to review the other slides, they're certainly available. And if you want them to be sent to you, just let Justin know and we'll send them to you. That if you don't need to see them because you know where they are and you can access them at your leisure.
I can just look there.
That's fine too. Okay.
I'll have the slides posted by the end of the day today on the website.
All right, great. Thank you, Justin. Anyone else? Rocky?
This goes back a little bit. I thought the point that you made when you asked the professor a question about Ohio's decentralized system is going to be a real key issue for us when we make a recommendation. And I would ask it maybe in the next presentation if you might have the speakers address that to see what they think. Because, we can adopt recommendations and implement standards on this issue and ask for those to be enacted into law and into rules as appropriate. But then the implementation is how are we going to do that? We have one statewide system when you have jurisdictions like Cuyahoga County and other large jurisdictions that are already working on this and want to do it independently, or is it going to be one statewide system? Obviously in the rural counties, the resources aren't there to have their own units, so they're going to have to rely on some sort of regional or statewide unit. So, I guess that's one of the things I'd be interested in seeing if they have any recommendations on that, because I think that's going to be a real challenge in making any recommendations that we end up proposing be effective.
Okay. We'll make sure that our next presenters will have that question prepared to be responded to. Okay. The other thing Doug, I'm not trying to put you on the spot, but as the representative of the AG, that there's a role that the state AG's office will be playing, and to the extent that we've not discussed, but we probably should, the manner with which internally you're viewing a systemic review of maybe modifying or putting some statewide overlay on that, it's worth further discussion. So
yeah, I think some of it would require legislative changes simply because it wouldn't be an option. We wouldn't have the authority to take certain actions or even do anything beyond make some recommendations on anything ourselves without some action that way.
And Yeah, right. Understand to adopt it would require legislative change. That's different from whether or not the state attorney general would be recommending the adoption of that legislation. So, which is worth further discussion, I think, going forward. So, all right. And since you're the spokesperson for the AG today, I address it to you. All right, thank you. Anyone else then? Comments, questions? Judge McIntosh? Nothing? All right, you're all good. You asked your questions and they were excellent questions. Well, if nothing else then, Justin, did I miss anything?
Nope, I think that covers everything, Judge.
So our next meeting is November 5 at 10 a.m. We'll have the brainstorming idea session. What we're going to send you back is a listing of all the brainstorming ideas so that everybody sees what everyone has suggested. And we're organizing it in a manner that I think we'll be able to vet those issues and make some decisions about which tasks and which ideas we want to move forward with on the task force and which we may not want to prioritize as high, and which will then guide us in terms of our work going forward. And then, of course, the November 19th meeting thereafter with D.A. Krasner and his CIU director. So anything else then? Thank you all then for your time. I appreciate it very much. Let's move forward. Have a great day, everybody.